Delivery of judgment. Item 1, WPC 624/2019.
Yes, sister, you can pronounce the judgment.
Sir, I'm sorry, I got another, because I had another delivery of judgment, that I brought another file with me.
Okay, so I'll pronounce
With
it.
Justice Sanjay Medhi.
Okay, I'll pronounce it then.
Yes.
Okay. The matter is remanded back to the tribunal for consideration of the entire documentary as well as oral evidence. Within 1 month from today, the petition is required to appear. The records are to be sent back. Petition is partly allowed. Pronounced by Sister Khan.
My lord, I beg to item number 16, my lord. In this case, my lord, Mr. Sudhir is, my lord, suffering from last 2 days, my lord. So for the time, for the day, my lord, let me pass out to the board. My lord, let it on Friday, my lord. My lord. Police.
May I please, Your Lordship, I beg to mention item number 6. Actually, I'm not in this case on behalf of Purnima Badua Badalai. She had yesterday night she had to leave for Bangalore due to medical reasons. So kind item 6. Yes, Lordship. Yes.
Name has been mentioned here. I don't designate it. 6 one, I don't
But,
know.
but her name is also not shown in the call list. So he instructed me to take that on her behalf. Legally conflict. Lordship, she was appointed as legal counsel on 18 August 2025.
Just wait till the matter is called, because since it's a legal aid case and the appeal has the delay is condoned, we'll pass appropriate orders in this. We'll record your presence on her behalf and pass necessary order. Please wait till the matter is called.
May I please, my lord? Now, with the consent of petitioner, I beg to mention item number 10, my lord. And for the respondent number 2, my lord, legal aid counsel, my lord. Those may take it after 2 weeks, my lord.
10. Okay. Both sides are presented on the prayer made by to the applicant. The matters will adjourned today. List after
2 weeks, my lord.
2 weeks.
Deeply.
Well, I beg to mention for listing a
This thing gave it to the court.
Order.
Item 1 for admission.
AP for the state, senior counsel assisted by Ms. R. Saikia, learned counsel. Next paragraph. By filing this interlocutory application under section 430 of the BNSS, the applicant is seeking suspension of the sentence imposed pursuant to judgment and order of sentence dated 1/1/2024, passed by the learned Sessions Judge Sonitpur in Sessions Case number 32 of 2001. To stop by the said sentence, the applicant was ordered to undergo rigorous imprisonment for life with fine of rupees 20,000 with default stipulation for committing offense under section 302 of the Indian Penal Code. Next, in brief, the case of the prosecution is that on 25/6/2020, while the applicant, along with his deceased wife and a child, were sleeping in their matrimonial home, the wife was found assaulted by a sharp weapon with profuse bleeding on the bed and under the bed. And accordingly, one Kafoor informed the Mahabhairav police outpost under Tejpur police station, resulting in Mahabhairav OPGD entry number 481 dated 25/6/2024 regarding the incident. Subsequently, one Mohammad Mukhtar Hussain lodged an Ejahar with the in charge of Mahabhairav police outpost under Tejpur police station, alleging that his sister, Muhammad MUSSTT, Taslima Nasreen, was killed by the applicant with a sharp cutting weapon with assault on her neck and other parts of the body. To stop, the victim was shifted to the Tezpur Medical College and Hospital, but the doctor declared her dead. Next panel. In course of trial, the prosecution had examined 13 witnesses. And on closure of the prosecution evidence, the statement of the applicant was recorded under section 313 CRPC. On appreciation of the evidence on record, the learned session judge held the appellant to be guilty of commission of offense under section 302 IPC and imposed the sentence as indicated herein before upon the applicant. Next paragraph. The learned counsel for the petitioner applicant has submitted that the applicant was on bail all throughout the trial and he appeared before the learned trial court when judgment was pronounced and the sentence hearing was conducted. Accordingly, it is submitted that as the applicant had never violated any conditions of bail, this was a quick case to suspend the sentence imposed on the applicant. Next paragraph. It is further submitted that the impugned judgment cannot be sustained because of the fact that the prosecution had not examined one Gopur, GOFUR, on whose information the GD entry was made. It is submitted that at the time of alleged incident, the then 4-year-old minor child of the petitioner was also in the same room, but he was not examined. He and other relevant witnesses available in the locality were not examined. It further submitted that the prosecution had not been able to retrieve the weapon of assault, and therefore the applicant could not be connected with the commission of the offense. Next, it is further submitted that in defense, the applicant did not take a plea of denial of his presence in the house and rather admitted that the applicant was in the same room where the deceased had been killed. And it is only when the minor child started crying at about 3 a.m. Yes, 3 a.m. He made a hue and cry, and inmates of the house, including the first informant, came in and saw the dead body. So it is submitted that the applicant had not made any attempt to escape from the scene of occurrence. And therefore, it is not believable that the petitioner would have murdered his wife after 15 years of marriage. It is further submitted that as per the evidence of the IO within bracket PW 13, bracket closed, it can be gathered that the house of the petitioner was shuttered with a bamboo gate, which was tied with a rope. Accordingly, it is submitted that any person could have entered into the room of the applicant and had committed the crime. Accordingly, it is submitted that the applicant has been framed with the charge of murdering his wife. That the story of the PW2 of demanding dowry from his wife not believable. Mr. Mahanto,
My lord.
anything we have missed out?
My lord,
Any of your submissions that we have missed out?
I have missed out, my lord.
No, no, your submissions made.
Yes, ma'am.
Have we missed out anything in the order?
My lord, there was no any specifically I can say that right now, my lord.
The dictation you did after point.
Yes, ma'am, please.
Next paragraph. Per contrast, the learned APP has referred to the objection filed by the state. He has opposed the prayer for suspension of sentence on the ground that the incident had occurred in the confines of the house of the applicant. And the presence of others in the house could not be established. So accordingly, it is submitted that under section 106 of the Evidence Act, it was the onus, the burden and onus was on the applicant to prove as to what had actually happened inside the confines of his house. It is further submitted that the postmortem report indicates several injuries suffered by the deceased, which included bone deep cut. Accordingly, it is submitted that with the nature of injuries, it is not believable that the applicant would not have known about the previous assault. Next, it is submitted that the PW2, who is the first informant, had referred to the PW2 had provided the motive of murder because, as per his evidence, the applicant had demanded money from the deceased. Next one. Next one. Having no, we have considered the submissions made by the current conflict courts General counsel for the applicant as well as the senior counsel for the state. Consider the materials available on record. Next one. At this stage, the court is disinclined to evaluate the evidentiary value of the witnesses examined by the prosecution. Nonetheless, in light of the submissions made by the learned counsel for the applicant, the records, the trial court records have been perused. It appears from the nature of evidence on record that on UN cry being raised, when people gathered at the place of incident, the only inmates in the house were the injured wife of the applicant, the applicant and his minor son. As per the evidence of PW4, the wife of the applicant was lying unconscious on the bed in a pool of blood. The postmortem report reflects 3 grievous injuries indicating bone deep cut over the right side of the neck and 4 centimeter below the right earlobe and 3 centimeter below right angle of mouth. And similar bone deep cut on the right side of the neck. With incised wound over the left hand above the wrist joint. In view of the nature of injuries reflected in the postmortem report, at the stage of consideration for bail, it is very hard for the court to accept that the applicant who was sleeping in the same bed with his wife would not have a disturbed sleep with the nature of injuries which were found to be inflicted on the injured wife, who was later on declared to be dead at arrival in the hospital. The there's no material on record to suggest that an outsider had an access to the free access to the house of the applicant.
My lord, one thing, my lord, may I, sorry to interrupt, my lord. The question number 35, my lord, that has been under 313. It is while he was asking the my lord about the stories, my lord, he has narrated the things. So far the 106 is concerned, that will come, my lord, when? That will be, my lord, when the prima facie case is established against me, then that will burden going to go to me, my lord. So far the
We are
question,
not evaluating evidence at this stage.
but the evidence act, my lord, the 106 will, my lord, not come in automatically, my lord. This is whenever the matter will be in all prima facie case, my lord, this has been proved against me, then, my lord, the burden will be shifted to me in case of the exceptional provision is there.
That may be good for a trial, the hearing on the.
But the
Very-
only, my lord, that aspect, my lord, question number 35, my lord, kindly see, my lord, of 313. How I answered, my lord? Somebody has done. Swali, he specifically said it on his hearing the hue and cry of the daughter, he awake. And
That we have already recorded. That we have recorded.
but this is also in whenever he was particularly asked the question about the incident, what he would describe. This is also been, my lord, stated by him. These other witnesses saying, but his person. And
That we have
regarding,
recorded. That we have recorded.
yes, my
It's not
lord,
that we have not recorded it. We have just not mentioned question number 35. We have recorded that you woke up on the cry of the child. That we have recorded.
yes, so my lord, they kindly say, my lord, my house, how it is built. It is a, my lord, purely bamboo house with rope, the door are tied with rope. And my lord, it is also not coming from
Mr.
the
Mohammed, we have
evidence.
recorded that.
My lord, one thing, my lord.
We have recorded that. We have taken into consideration.
Yes, my lordship has lightly discussed, but the one thing, my lord, there is no any proof to say that after hewing and crying, my lord, who has opened the door? Nobody has seen, my lord. Everybody say, I have seen, I have seen. Who has opened the door, my lord?
Oh, for that, you'll have to take us to the evidence recorded. None of the witness was cross-examined on that. None of the witness was cross-examined. You see, for bringing a defense, you have to build up a story in the cross-examination. That is not even suggested in the appellate stage to discard the evidence on the ground that nobody said who opened the door. You see, opening of the door is not a relevant factor in a murder case. You were inside the room. You will have to show that when the people entered, it was open. It was wide open for others to have entered during the absence.
But the, my lord, the evidence, my lord, who has not examined the Gafur, he has informed, he is specifically saying in the even the PW4 also.
Mahanta, we have records. If we have missed out anything, we have asked you whether we have missed out anything. For us being considered, we are not changing our opinion.
That is true, my lord, but my responsibility being an officer, well, I have
No,
to
that's
show the,
okay.
show the particular things to your lordship, my lord, because this is my
We have
duty.
not
That is why.
We have not missed any of those statements. We have recorded that.
Okay.
Accordingly, the court is of the considered opinion that the nature of evidence, the materials which are available on record do not are not sufficient to make out a case for suspension of sentence of awarded to the applicant. Accordingly, as the it does not without the suspension of sentence because the applicant was the only adult member of the family in the house. where the deceased was found dead. Resultantly, this application for suspension of sentence stands rejected and dismissed. Next. This application stands disposed of. Next para. In the main case, you write the so P. Mohantal, counsel for the appellant, and Ms. D. Buyar, and APP for the state, senior counsel assisted by Ms. R.
JSA. JSA.
KSAK. Learned counsel. I'm sorry, I forget names. I'm old. I'm an old person. You'll have to excuse me for that. I'm extremely sorry, but can't help it. Present, next para. Pursuant to the earlier order of the court, the records of the trial court record is received. The registry shall prepare a paper book. Next. List. Give a date after 5 weeks, 6 weeks, giving them time to prepare. List on Wednesday, awaiting preparation of paper book.
Well, any specific time is given.
You give a date. They will give the dates.
No, sir.
We have so many holidays in January that they are
Yes,
finding it difficult. They'll consult the calendar and give a date.
It's not been confirmed that how many days will be there also.
No, that is how we have to.
New calendar will come only.
No. Mr. Mohanto, you just get us approval of the bar that they would not object to the increasing of the working days. We are ready.
But before that, there is some consensus
But
opinion.
till then, we'll have to reconsider the dates and then they'll give a date. In paper
Must-
book cases, they are giving date.
8th of January. No, sir.
We'll take a short break and come back.
An IA is prepared for condemnation of delay of 77 days, preparing in criminal appeal jail against the Boxer case number 150 of 2024.
Okay. Your name?
A. Hussain, Your Lordship.
A. Hussain. Heard Mr. A. Hussain, learned counsel for the learned
On
counsel
behalf of-
appearing on behalf of Mr. B.K. Sen, learned legal aid counsel for the appellant. Issue notice on this interlocutory application under section 5 of the Limitation Act for condoning the delay of
77 days.
77 days beyond the period of limitation in filing the connected jail appeal. Issue notice returnable on returnable on so and so. Mr. R. Kaushik, learned APP accepts notice on behalf of respondent number 1. Next, the appellant, the learned legal aid counsel shall take steps within 2 days for service of notice on respondent number 2. You take it from the secretary that the registry upon after processing the steps shall hand it over to the office of the public prosecutor Assam for onward service on respondent number 2 to the jurisdictional Lahorighat police station. Next, the notice, it shall be communicated that in the event the respondent number 2 is unable to engage a learned counsel, he can apply for assistance of a legal aid counsel. He can apply for legal aid counsel. Next para. List also awaiting service of notice on respond by two. Just before that, you also say the officer in charge of Laharigarh police station shall ensure that
Item 14.
May I plead the Lordship? Lordship, this I is for condonation of delay of 226 days in filing the connected appeal. Lordship, that is delay of 226 days in filing the connected appeal.
the six. 366. Okay, same order. Heard Mr. S. N. Tamuli, learned counsel for the applicant. Here also same notice on same written date, notice on respond by two. Same as previous order, no?
Lordship, only there was mistake on my part because the judgment was not annexed. Though I have marked it as annexed, I am allowed to annex the copy of the judgment with the I.
In this application,
Yes, Lordship.
okay.
Due to some
Before the
mistake,
last line, you say, on the, prayer made by the learned counsel for the applicant, Amma is permitted to annex the copy of the judgment and impugn judgment and sentence
dated
to this
10/9.
application. To stop the same shall be done in the presence of AOJ Criminal Appeal Section.
Much obliged.
Supplementary list, item 18 for orders.
May it please, my lord. This IA file for suspension of sentence, my lord. Notice was issued, my lord. Objection was not filed.
Will file objection, my lord.
Yes,
Will file objection.
it's not on record.
Well, we have not filed, my lord. We'll
You
file.
have not
Till
filed.
today, they have not filed.
Paper ready हो रहा है.
ये तो कोई ना कोई व्यक्ति न हो. यहाँ पे काम की कितनी देते हैं.
Okay.
इसमें एक आपको देते जाने की. M को लिखा. M को लिखा.
My lord. My case paperwork is also not ready, my lord.
Or are you? Yes.
Otherwise, PCR received. My lord. What happened?
Well. Well. Obliged. Yes. Yes, madam. Mr. Report. Obliged.
Supplementary item 19 for orders.
Wait, please, your lordships. Appeal has already been admitted, lordship. Notice has been served. This is a POXO. Pardon, lordship. Dangerous people, lordship. I could not follow, lordship. Maybe, lord. So we have filed this IA for suspension of sentence, lordship. We have annexed almost all the copies, lordship, of the evidence, except one part I have missed here, lordship. Today, just on going to the record. The further examination of PWT in the medical office, we are not harping on that part, lordship. So I may be allowed to proceed, lordship. So
Noyanjuli does. He does my cases. He comes. often. My lord.
Item 17 for hearing.
Yeah, please, your lordship, my senior is on the legs in another court. He will be coming here.
My lord, I'm appealing for the respond number 2, madam.
Item number
17, madam. Item 17, madam.
62. Single bench item 1 bail hearing. BA 3213/25.
You take to me, one right, one do not. One do not. One do not. Then I will hit it over. May I refresh my lord? I will. Yes, yes, yes.
My lord. I just, my lord, refresh your lordship on 3 counts. Number 1, my lord, I have prayed for the bail of the particular accused, my lord. First, on the ground of verity, since this honorable court has passed an order of bail in regard to the co-accused. That is number 1, my lord. In view of Section 50 not properly, my lord, complied with. Section 50 of the CRPC as well as Section 52 of the NDPS Act. My lord, that is at page 68 of my petition, my lord, 68. Arrested on the same day, my lord, and similar, same, only the name is different, same CRPC 50 notice was served without, my lord, the grounds of arrest. So page 68 is the, my lord, bail order of Monirul Islam. Yes, only on the ground that, my lord, 50 CRPC has not been followed as a mandate of constitution, my lord. So it was mandatory and it will override 37 of the NDPS Act. I, my lord, at the same time, pray for parity. Since, my lord, same forwarding report, these 3 people were arrested, and this particular present accused prisoner is one of them, with the same footing of that of Monirul Islam. This is my number 1, my lord. And for that, I have given some rulings also, my lord. Vihan Singh and mainly Vihan Singh, my lord. Yes, Vihan is the main, my lord. That is where Honorable Supreme Court has cited that it has to be mandatorily followed. Now, my lord, my learned friend, my lord, by filing an additional affidavit on that ground, said that compliance not necessarily under 50 means that has to be in the 50 CRPC only. It can be by way of the arrest memo or the intimation. I here, my lord, specifically differ, my lord. Reason being, I have cited one example. That argument was that, my lord, in this present case, an arrest memo discloses the material particulars of arrest. As well as an intimation was also to the family members, which also reflects the same. That may be complementing the Section 50. That was the submission of my learned friend through that affidavit, what I understand, my lord. So 50, if 50 does not disclose, read together these 3 would amount to enough sufficient address of grounds of arrest. Here I differ, my lord, on the ground that Section 50 has to be seen on its own perspective, independent of the arrest memo. I have submitted one judgment of the Honorable Supreme Court also, that arrest memo and the Section 50 CRPC are not the same thing. Where arrest memo is just a procedural thing, my lord. The arrest memo, my lord. Judgment I have cited. I have yesterday, day before yesterday, my lord, that is Probir Purkayastha versus State of NCT. No, sorry, my lord, sorry. Ashish Kakkar versus Union Territory of Chandigarh, my lord. Here one paragraph which says, my lord, 7th paragraph, that being a clear non-compliance of the mandate under Section 50 of the Code, which has been introduced to give effect to Article 22 of the Constitution of India, we are incited to set aside the impugned judgment, particularly in line of the judgment rendered by this court reported at Probir Purkayastha versus State of NCT of Delhi. I rely on this, my lord, that Section 50 has to be independently and mandatorily complied with, irrespective of the arrest memo, whatever it contains, my lord. Arrest memo cannot complement Section 50. Ashish Kakkar, my lord, it's a new recent 2025 dated, my lord, very 25/3/2025 decided. One page, my lord. But it says, my lord, the spirit of Probir yes, my lord, it says Probir Purkasta has to be taken care of. And therefore, my lord, it says, my lord, upon perusing this, we see that provided in the appellant only, appellant is on provided to the appellant is only as arrest memo in the prescribed format, which is meant to be given to the appellant by way of an intimation. It has been filed with the name of the appellant along with place of arrest. Additionally, it has been written that it has been arrested based upon the statement of the co-accused. We are in agreement with the submission made by the learned senior counsel appearing for the appellant that the said arrest memo cannot be constituted as grounds of arrest, as no other worldwide particulars have been furnished to him. So, my lord, here only I will just want to distinguish, my lord, arrest memo and CRPC 50 notice, my lord. Arrest memo is just an intimation, my lord. And CRPC 50 is a mandatory, my lord. It has to be done, my lord, for to safeguard the defense of the accused. This is my first ground, my lord. And second ground is, my lord, almost 2 years, 11 months, my lord. My liberty at stake. And number 3, my lord, out of these years, my lord, he is in jail. Only 4 witnesses have been examined. And nobody has, I have annexed that, my lord, nobody has implicated the present accused. Even the informant has not, if your lordship go through the informant's version, my lord, this accused is not incriminated, my lord. So my final prayer, my lord, considering these facts, my lord, although this honorable court has, in another matter, my co-accused has been allowed to go on bail, I pray for the same parity, my lord. That must come.
Yeah, please. Lordship, recently Supreme Court says that long inclination or delay in trial is not a ground of arrest, granting bail. Lordship. Long inclination or pending of trial is not a ground for granting bail. Lordship, on 13/11/2025, Supreme Court has passed an order, paragraph 13 onward, Lordship. Lordship. Lordship, very different judgments are one of on different time. And this is another judgment recently passed by Honorable Supreme Court. What's paragraph 11? Here, Lordship, purpose of the NDPS agreement discussed. So another judgment, that is Title Union of India versus Namdev Asruban Nakade. It was pronounced on 7th of November 2025. I want to, in this case, Supreme Court dealt with the purpose of NDPS Act. Lordship, paragraph 9, 10, and 9, Lordship, page. This is not given, Lordship. May I read it? Paragraph 9. The Union of India versus Namdev Asruba Nakade. Lordship, I have already provided him. That's the paragraph 9. Paragraph 9, Lordship. 9. May I read it? Start from in India. In India, there has been concerning increase in drug abuse among the youth. Substance abuse not only affects individual, families and communities, but also undermines various aspects of health, including physical, social, political, cultural, foundation and mental well-beings. Then, paragraph 10. According to many news reports, India faces a clear dilemma between tackling the narcotic crisis systematically or sacrificing its most valuable resources, that is, its young people. The content of millions of drugs also been highlighted by this court in case of Ankush Bipin Kapoor versus and National Investigating Agency. Paragraph 9.1. The ills of the drug abuse seems to be shadowing the length and breadth of our country, with the central and every state government fighting against the means of substance abuse. The debilitating impact of the drug trade and drug abuse is an immediate and serious concern for India, as the global grapples from the means of the escalating substance use disorders and an ever accessible drug market. The consequence leave a generational page of 75 to 84 imprint on public health and even national security. Article 47 of the Constitution makes it duty of the state to regard the raising the level of nutrition and standard of living in its people and the improvement of public health as it's among its primary duty. And in particular, the state shall endeavor to bring about prohibition of the consumption except for medical purpose or intoxicating drugs, drinks, and for drugs which are injurious to health. The state has responsibility to address the root cause of this pediment and develop effective intervention strategy to ensure that India's young population, which is particularly vulnerable to substance abuse, is protected and saved from such means. This particularly because substance abuse is linked to social problem and can contribute to child malnutrition, spousal violence, and even property crimes in family. Paragraph 11. In this present case, the court finds that though the respondent accused was in custody for 1.5 months, 1 year, 4 months, and charges have not been framed, yet the allegations are serious in much as only its recovery much in excess of commercial quantity but the respondent accused allegedly got the cavities indigenously fabricated below the letter to conceal the contraband. Prima facie, this court is opinion that the respondent accused is involved in drug trafficking in an organized manner. Consequently, no case for dispensing with the mandatory requirement of section 37 of NDPS Act is made out in the present case. Moreover, this court is of the view that as an accused has been charged with offense punishable with 10 to 20 years rigorous imprisonment, it cannot be said that the respondent has been incarcerated for unreasonable long time. This judgment deals with two aspects: one, long incarnation, and second, the purpose of the act. Lordship, here the same view has been expressed by this honorable court in Burgess case that has placed paragraph 13 to 22. And with regard to violation of the act, Lordship, I want to place one judgment passed by your Lordship, that is Jitul Ali and others. Same Lordship, same memo,
Yes.
arrest and notice under section 50 was voted by your Lordship. On last occasion, I submitted that judgment, Lordship. Again, I'm submitting it here. Yeah.
Co-accused, my lord.
He's a co-accused. He's a copy. Same arrest memo say notice under 50 was quoted by your Lordship. And the section, particular section has been quoted. Or bail application of this bail application. No. We have filed additional affidavit. What's it? Additional affidavit, page 95. We file additional affidavit, it is available in the record. Last case, it was not available in the record, yesterday. The Lordship is directed to place the Lordship may take up my application, my copy law. No, so there, we file additional affidavit, we will record the arrest memo and other. Opposition also filed. This is my copy. Lordship. Yes.
Yes.
Copy was given.
I
to
have.
you. Lordship, further, he approached this honorable court twice and not before the trial court. Both the, on the three occasions, Lordship, bail application was considered, was rejected. Lordship, page 22 of the bail application. Page 22, is the first order dated 25/1/2023. And lordship, page 31 also. Then page 46.
জাজমেন্টটোতে ৰিফ্লেক্ট কৰিছিলে আগৰবাৰ কালি ডেট আছিলে এইটো কি কৰে That was they have that part of them that put examine only 3 witnesses out of 12. It's a pattern. My lord. Yes. Yes. My lord, no issues. My lord may take my lord's time, no problem. We are okay with it. Yes. Yes, my lord, yes. Yes, yes, sure, my lord, sure. Yes, my lord. My lord, my one prayer, my lord, this judgment may be, my lord. Yes, that I have Ashish Kakkar, that may be my lord.
That has already been referred by your lordship in the Jitulali's case.
In any manner.
Yeah.
My lord. Tomorrow I'll inquire, my lord, in the morning. Yes. Yes. Yes, my lord. Yes. Yes, ma'am. Yes, ma'am. Yes, yes, ma'am. We can see, my
The
lord.
condition of the law.
My lord is not well.
Now,
Hmm.
Weather is changing.
Change
lordship,
of
and
season.
I am also for last 15 days suffering from cough and cold.
Change of season, my lord. That is-
And we are used to in the AC rooms. That also affects our health. Lots.
My lord.